Welcome to the House Criminal Justice Committee for Wednesday, March the 10th. Thank you, sir. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Holsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio. Chairman,
Here.
you have a quorum.
Thank you, Madam Clerk. Members, before we get started tonight, any personal orders? Anyone have any guests here with them? Anyone they'd like to recognize? Seeing none, we're going to get right to it. We have quite a bit on the calendar tonight. We have quite a bit coming behind us at a sub. And so out of respect for some bills that have been parked for a little bit, we are going to be jumping around a little bit tonight. So we want to make sure that we get to as much as we can. And we also have members who've got to get to meetings elsewhere in the building. So we would like to jump to item number 15. Item number 15, House Bill 534. That is by Chairman Howell. Chairman Howell, you're recognized. Sir, you have a motion and a second. You're recognized on the bill.
Thank you, Mr. Chairman. This bill came to me from the School Safety Committee of the Bradley County Sheriff's Department. It amends the TCA code to allow a judge to hold a juvenile for psychological evaluation when it's determined that that juvenile has made a credible threat against the school or fellow students. And they tell me it's important to determine if that juvenile is a threat to themselves or to others in order to give them the help they need. Be glad to answer any questions.
Thank you, Chairman Howell, for that explanation of the bill. First on my list, I have Leader Lamberth. You recognized. Previous question. Members, previous question's been called. Without objection, we're ready to vote. All those in favor of sending House Bill 534 to Finance, please signify by saying aye. Those opposed? Sir, you head to Finance. Thank you very much. Now we will move to number 5 on your calendar. Item number 5 by Chairman Zachary. Chairman Zachary, you still in the room? Sir, you have a motion and a second. You're properly recognized.
Thank you, Mr. Chairman and committee. Members, a rare bill that's supported by Mothers Against Drunk Driving and Anheuser-Busch, currently in code related to social hosting. The term underage is used, which only applies to 18 to 21. We're simply changing that word to minor. So if you social host high school children, you can be charged with a misdemeanor, pay a $1,000 fine, and community service. I'll be glad to answer any questions.
Thank you, Chairman Zachary. Members, you've heard the explanation of the bill. Representative Dixie, you're recognized.
Does this still include the 18 to 21?
Yes, yeah, minor is every, sorry, Mr. Chairman.
Oh, I'm sorry. Chairman Zachary, you're recognized.
Minor is 21 and under. Right now, the way that term underage is only 18 to 21, minor is everyone 21 and under.
Representative Dixie for follow-up.
No, thank you. I did not know that.
Thank you.
I just assumed minor was under 18.
Thank you, sir. Representative Griffey, you wish to be recognized? Thank you, sir. All those in favor of House Bill 150 signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you, Mr. Chairman and committee.
Thank you. That takes us to item number 6, House Bill 384 by Chairman Crawford. Chairman Crawford, you're recognized. Sir, you have a motion and a second. You're properly recognized before the committee.
Thank you, Mr. Chairman. Thank you, committee. I think I've spoken to everyone on the committee. This is the Evan Boswell law that we passed last year out of the House that the Senate didn't take up. It does have the amendments included from Judge Carter in it. I'll be glad to answer any questions.
Members, you've heard the explanation. Leader Lamberth, you're on the list.
Previous question.
Previous question's been called. Without objection, we're ready to vote. All those in favor of sending House Bill 384 to Calendar and Rules, please signify by saying aye. Aye. Those opposed? Sir, you head to Calendar and Rules.
Thank you, Chairman. Thank you, committee.
Thank you for an excellent piece of legislation, sir. Next, that brings us to item number 8, House Bill 428 by Chairman Littleton. Chairman Littleton may not be here. If someone wouldn't mind trying to text Chairman Littleton. And I will move on to item number 19 on your calendar. Item number 19, which is by me. And I will pass the gavel down to our Vice Chairman, Vice Chair Sexton.
Thank you, Chairman. Curcio, you are recognized.
Thank you, Mr. Chairman. And I have an amendment. Thank you very much.
You're recognized on the amendment.
Thank you, Chairman. Members, I've spoken to many of you about this, but this makes some critical changes, some much-needed changes to the Juvenile Justice Reform Act, something that we've been working with the family and juvenile judges on across the state now for a number of years, and I'd be happy to answer any questions.
We need to get a move in a second on the amendment first.
Sorry, and this is amendment coded 4215, just to clarify.
Question on the amendment, any objections? Seeing none, all in favor say aye.
Aye.
Opposers, no. The amendment carries. We are back on the bill.
Thank you, Chairman, and thank you, committee. Members, the amendment makes the bill. Be happy to answer any questions.
We have Representative Hardaway.
Thank you, Mr. Chairman. And to the sponsor,
Yes, sir.
the periodic reviews of the status of the detention, is that in or out now?
Thank you, Mr. Chairman, and thank you for the question, Representative. So I want to make sure we don't confuse the matter. The review that's mentioned is at the end of that child's sentence. So the reason that existed at 6 months was because that was the presumptive cap. Moving forward, this bill were to become law, the judge is able to review that case anytime that they need to. So since the 6-month cap is going away, that's why you see that review language going away. But nothing in this bill would preclude them from having a review whenever they needed to have a review. It's just that right now, since there is a cap, there is mention of the review at the end of the sentence.
Representative Hardaway.
Thank you, Chairman. And I'm wondering, will we have concerns on, well, first I need to get clear, is it possible for the child's parents or counsel to request the review within that detention period?
Chairman Curcio.
It's my understanding that they could request that of the judge.
Okay, then that takes care of my concern then. All right, thank you.
Thank you, sir.
Thank you. Any other questions? Questions been called. Any objections? If not, all in favor of this manifest by saying aye.
Aye.
Opposers, no. Motion carries.
Thank you, Chairman.
Move on to Calendar and Rule Finance. Thank you.
Thank you, sir. Members, that brings us back to item number 8 by Chair Lady Littleton. Ma'am, you have a motion and a second. Properly recognized. Thank you for, sorry, we're jumping around a little bit, so thank you for.
I was in education, so I just jumped right over here. Thank you.
Excellent. Ma'am, you have a motion and an amendment, and that is on amendment coded 4578. Is that correct?
That's correct.
You're recognized, ma'am.
Thank you. And it makes the bill, but we also have a clerical that is untimely filed. It just changes as to at. And that number is 4668.
Thank you, Chairman Littleton. What I would, with your indulgence, what I would request is we'll do an oral amendment, and that way that'll take care of it since we're not able to take up untimely filed written amendments.
Perfect.
But it's
Okay.
grammatical in nature, so I want to make sure I get that correct, though. So I think it's in the system. Members, without objection, we're going to go out of session for legal services. We're out of session.
Michelle Fogarty, Legal Services. As I understand it, in Section 2 of the bill, Subdivision L, the oral amendment is to change the word as to at, and that's it.
Yes, ma'am, that's the request.
Okay.
All right, thank you very much. Back in session. Do we need to vote to adopt the oral? So members, the posture we find ourselves in, thank you, I had to phone a friend. Yes, Chairman Littleton.
I never realized the word "at" would cause so much confusion.
Right, I know, I'm sorry. The posture we find ourselves in is we need to adopt Amendment Coded 4578. If we could get a motion to do that, and then we'll orally amend that amendment. So I've got a motion to adopt Amendment 4578. All those in favor of adopting Amendment Coded 4578, please signify by saying aye. Those opposed, you adopt. And now, members, we are considering an oral amendment to Amendment Coded 4578. Can I get a motion? Have a motion and a second. All those in favor of the oral amendment, please signify by saying aye. Those opposed? All right. And now, without objection, we will roll both of those amendments into one. All right. Members, we are now on House Bill 428 as amended. Chairman Littleton, you're recognized.
Thank you, Mr. Chairman, and I'm sorry for the confusion, but I've never known that word to cause so much confusion. But anyway, thank you. In 2019, the aggravated rape of a child statute was amended to require the sentence would be life without parole. The U.S. Supreme Court has ruled in Miller and versus Alabama that the Eighth Amendment forbids a sentencing scheme that mandates life in prison without the possibility of parole for a juvenile. To guarantee that the statute is constitutional, this bill would create a separate section for the sentencing of offenders who committed the crime as a juvenile. It would allow for the mandatory sentencing of life without parole for adults, but juveniles will be transferred, would receive a sentence within the range 3.
Thank you, Chairman Littleton, for working on this important issue. Do we have any questions for the chairlady? Questions been called by Chairman Farmer. Oh, sorry, Representative Hardaway.
Thank you, Mr. Chairman. And this question is in relationship to juvenile on juvenile crimes. How would this impact, let's say, if an 8-year-old raped an 8-year-old? Are we talking about 40 years for that child before, well, yeah, it's possible that that child could be tried as an adult and sentenced to 40 years, or do you have some allowance for the age differential between the rape victim and the culprit?
Chairman Littleton, you're recognized.
It says that they would be a range 3 offender.
I'm sorry.
Representative Hardaway.
I didn't understand.
If they're sentenced to adult court, they would still be a range 3 offender. Otherwise, they would be, as I guess, just a regular juvenile.
Representative Hardaway, do you wish to follow up?
Yes, sir. So if it's a child that's tried as an adult, then we're still talking about range 3, and we're still talking about serving the complete sentence minus the 15% credit.
Chairman Littleton.
That's correct.
Okay. Okay, I've just got an issue.
Representative Hardaway, you're recognized.
Thank you. And of course, I'm as strong as you are when we talk about any adult that preys on children. I'm just concerned about children crimes, and whether we throw out the opportunity for rehabilitation and being able to help them in their development going forward in these instances. So,
Chairman Littleton, you recognize.
This doesn't change the law at all for juveniles. This remains the same as it always has been. This is for adults that commit aggravated rape of a child, which is 8 and under.
okay.
We're taking the juveniles completely out of this bill.
Representative Hardaway.
All right. And Mr. Chairman, this maybe I need to hear legal on this, on how this would impact children on children crimes when the perpetrator is tried as an adult.
Chairman Littleton.
I'm fine with legal speaking up about that, if you don't mind. Thank you.
Okay, absolutely. Without objection, we're going to go out of session to hear from Legal Services.
Michelle Fogarty, Legal Services. There's an age limit at which a child can be transferred to adult court for prosecution of an offense, and an 8-year-old is below that age limit. So if an 8-year-old committed the offense, they would have to remain in juvenile court because they're not old enough to be transferred to adult court and tried as an adult.
Representative Hardaway.
Thank you, sir. And is there language that speaks to the age differential if the culprit is still a juvenile but over 8 years of age?
No, sir, not for this offense.
So could a 9-year-old, well, first, what's the minimum age for a transfer to be tried as an adult?
Ms. Fogarty.
I believe it's 14 for certain offenses. You have to be 14.
So that would automatically be at least a 6-year difference. Okay, I'm good, Mr. Chairman. Thank you, sponsor.
Thank you. Any other questions for legal while we're out of session? Seeing none. We're back in session. Chairman Littleton, you recognize.
Thank you, Mr. Chairman. Juveniles were inadvertently in the bill, and this removes juveniles from the bill. So this has no effect on anything that he's talking about because it takes them out of the bill completely.
Excellent. Next on the list, I have Chairman Farmer. Previous question's been called. All those in favor of sending House Bill 428 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Ma'am, you head to calendar and rules.
Thank you very much.
Thank you very much. Next, that brings us to item number 1 on your calendar. Item number 1. And that is by Vice Chairman Russell. Vice Chairman Russell, you are recognized. Sir, you have a motion and a second. I see there's an amendment coded 4137. You wish to move forward with that amendment?
Yes, Chairman.
Sir, you have a motion and a second on the amendment. Please explain your amendment.
Thank you, Chairman. What the amendment does is write the whole bill. It requires that after conviction of certain crimes that historically targets women and children, 100% of the imposed sentence must be served. Sentences cannot be reduced by credits. Credits can be used for the purpose of increased privileges, reduced security classification, or for any other purposes other than the reduction of the sentence imposed by the court. Plain and simple, if you do the crime, you do 100% of the time. No possibility of parole or probation. I renew my motion, Mr. Chairman.
Members, you've heard the explanation of the amendment. Any questions for the sponsor? Question's been called on the amendment. All those in favor of attaching amendment coded 4137 to House Bill 1047, please signify by saying aye. Aye. Those opposed, you adopt. Members, the amendment makes the bill. Any questions? Chairman Holsey, you recognize.
Okay, so you're saying that the penitentiary system cannot grant good time or good behavior time to take days off a sentence, but is it, for what particular crimes is it that applies to?
Vice Chair Russell.
There's a whole list of crimes in the amendment. I could have legal to go through every one of them if you'd like.
Well, I brought the wrong, I'm sorry.
Yeah, you recognize, sir.
I brought the wrong book, so I don't have the amendment or the paperwork. I didn't know how many particular crimes that involved.
I'm sorry.
Vice Chair Russell.
I'm sorry, I didn't hear the question.
Oh, just to clarify, I think he was just, if you could give a characterization of the crimes that were included and perhaps a number.
Oh, absolutely. So here's just a list of them: rape, aggravated sexual battery, aggravated sexual, statutory rape, indecent exposure, patronizing prostitution, promoting prostitution, public indecency is defined in 3913-517, continuous sexual abuse of a child, sexual battery by authority figure. There's a bunch of them. If you want me to go through every one of them, I could.
Chairman Holsey. Thank you, sir. Next on the list, I have Representative Lamar. You're recognized.
Thank you, Mr. Chairman. I just have a question about one of the offenses, promoting prostitution. One of my concerns is that people who are victims of human trafficking can oftentimes get accused of promoting prostitution as a result of their victim status. So how will we be able to protect them with this bill so we won't confuse them as someone who is, intentionally engaging in sex crimes versus perhaps being a victim of human trafficking, because the water gets muddy with the promoting prostitution part.
Vice Chair Russell.
Absolutely. This would be what they're convicted of, and that would be determined by a court of law because everybody's considered innocent unless proven guilty. And so whatever they're proven guilty of is what this would affect.
Absolutely. Okay.
Representative Lamar, you recognize?
Thank you so much. What about those who make the choice to engage in sex work as a means of survival? Will they be looped into this bill?
Vice Chair Russell.
If they're found guilty of one of these offenses, they would.
Representative Lamar, do you wish to follow up?
No, thank you. Thank you, Mr. Chairman.
Thank you, ma'am. Leader Lamberth, I've got you on the list.
Well, I was going to call a question, but I will say this. I mean, to the previous question, or the question that was asked right before this. This bill specifically goes after the traffickers. So, I mean, this is exactly what I think we would be looking for, is that this is going after the folks that are actually victimizing individuals out there and making sure that if convicted, and that's where, your DAs and judges and juries come in, but to make sure that if they catch, in the vernacular, a pimp, I mean, somebody that is out there trafficking other people and taking advantage of their circumstance and their lives, ruining their lives, that we make sure that person is locked up for a long time. And so that's the goal of this. And I was going to say, just listening to the recitation of the types of crimes that are here, it sounds like virtually every crime in this group of penalties that will be increased are traditionally crimes that have been committed against women and children. And so, I mean, it just... Not exclusively, but traditionally, I think that's probably the folks that are survivors of these type of crimes. And so I fully support the bill. I think it's a great criminal justice reform bill in order to be able, we talk a lot of times about, and the chairman says, making sure we're locking up the folks that we're afraid of and that are truly just wreaking havoc in our communities and not just those that we're annoyed at the time. And this bill appears to do that. I mean, it really goes after the worst of the worst. So thank you for bringing the bill, and appreciate that, Vice Chairman.
Thank you, Leader Lamberth. Seeing no other questions, we're ready to vote. All those in favor of sending House Bill 1047 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance. Thank you. That takes us to item number 18 by Representative Lamar. Motion. Ma'am, you have a motion and a second on House Bill 17.
Thank you, Mr. Chairman. Can I present from my seat, please?
Absolutely. Thank you.
Thank you, Mr. Chairman. This bill is a bill I've been working on with this committee on. What it does is if you commit bodily harm or death because your life is in danger as a result of your victim status of human trafficking, you can claim self-defense through testimony only in the courtroom. That's an explanation on my bill, and I'm opening it up for questions.
Thank you, Representative Lamar, and I apologize. I actually filed an amendment on this. It's amendment coded 4540. Thank you for that. It rewrites the bill. It's exactly your language, but it substitutes, rewrites the bill similar to the bill as filed, but substitutes unlawful activity with felony or Class A misdemeanor. There's another bill that's traveling that if they both passed would negate what you're trying to do here, and so this would bring them together so that bill does not impact yours, but the net effect on your bill is that your original intent remains completely intact.
Sounds good.
All right, thank you. Without objection, we're ready to vote. All those in favor of attaching amendment coded 4540 to House Bill 17, please signify by saying aye. Aye. Those opposed, you adopt. And now, question's been called on the bill. Without objection, all those in favor of sending House Bill 17 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Ma'am, you head to calendar and rules. Thank you, Representative Lamar. Great work on a piece of legislation we've been working on for several years now, so thank you. That brings us to item number 11. One moment, committee, just 1 second.
Do all three of them, it's okay. I mean, we have till what, 5? We got at least till 5? At least 5, yeah, it's fine.
Members, that's going to take us to item number 16 on your calendar. Sorry, we're jumping around. I just want to make sure I don't miss any of the folks we're trying to get to because they've got other meetings to be at. Item number 16, which is House Bill 1128 by Chairman Farmer.
And thank you, Mr. Chairman, committee members. What this does, we passed the Safe at Home Act through the Secretary of State's office back in 2019, which protects those who have been victims of stalking, harassment, and human trafficking and other sorts of domestic violence. What this does, this expands that. This has been so popular, and people take advantage of it to save so many lives that we want to expand that now to take care of people such as a new spouse, an adult child living at the home, and an elderly parent for which the victim is a caregiver of. So that way these folks can't track them down through these other individuals. So we'll mask their addresses as well to keep them safe, not just move passage.
Members, of that explanation, question's been called on the bill. All those in favor of sending House Bill 1128 to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules. Members, we're going to go to item number 7 on your list. Item number 7, House Bill 881 by Chairman Terry.
Thank you. And there's an amendment coming from the subcommittee.
Yes, sir. I see amendment coded 4221. Have a motion on that? And a second?
Right. Thank you, Chairman and committee. House Bill 881 is designed to help protect the right to peacefully protest for Tennesseans by cutting down on the bad actors that may escalate an otherwise peaceful protest into a riot. The bill is based on a psychological phenomenon called social contagion theory. Social contagion theory is when you have a group of individuals and one individual acts out or takes an action that may become contagious within that group of individuals. For instance, if you have a group that is peacefully protesting and someone decides to throw a rock or charge a building, it can become contagious within that group and escalate a peaceful protest to a riot. This bill addresses this issue by enhancing the charges for someone who has been paid to riot or has come in from out of state with the intent to commit a criminal offense. The penalties are a Class 8E felony with a mandatory minimum of 45 days of incarceration or 60 days if 2 or more of the acts in the bill are committed.
Members, you've heard the explanation of the amendment. All those in favor of attaching amendment coded 4221 to House Bill 881, please signify by saying aye. Aye. Those opposed? You adopt. The amendment makes the bill. Any questions? Seeing none, we're ready to vote. All those in favor of sending House Bill 881 as amended to Finance, Ways and Means, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you, Chairman and Committee.
Thank you. That brings us to item number 11. Item number 11 on your list by Leader Lambert. Sir, you have a motion and a second. You're recognized on House Bill 786.
Thank you, Mr. Chairman. And we have 2 amendments that came out of subcommittee, and if they have not, I don't believe they've been combined. There are 2 different amendments. Do we need to readopt those, Mr. Chairman, or?
We do. So the first one I have coded is amendment coded 3738. Have a motion and a second on that. Sir, explain your amendment.
And, Mr. Chairman, what this does, I mean, this is a very clean-cut amendment that just makes it clear that if you are lawfully in possession of a firearm and you are lawfully where you're allowed to be, then you will not be put in jail for not having a permit. It keeps the permit process out there for all that would like to take advantage of the permit process. We encourage folks to get a permit. In fact, we encourage folks to get training beyond just the one class. But this makes it clear that we're not going to jail someone that would have otherwise been a law-abiding citizen, but for the fact that we criminalize them carrying their gun without a permit. So that's what this amendment does. It is a clean-cut, constitutional carry bill.
Members, you've heard the explanation. I will say this and the amendment behind it are going to make the bill, so you may have a lot. Question's been called. Without objection, all those in favor of attaching amendment coded 3738 to House Bill 786, please signify by saying aye.
Aye.
Those opposed? You adopt. That brings us to amendment coded 4089, also by Leader Lamberth. Sir, you're recognized on amendment coded 4089.
Thank you, Mr. Chairman. In this, so in the current law, if you've been convicted of stalking, if you've been convicted of 1 DUI in 5 years or 2 in 10, if you've been judicially committed because of insanity, or you're otherwise prohibited to possess a firearm, then you cannot get a permit. So again, we have the other amendment takes care of this section of this that would be referred to as constitutional carry, makes it very clean and straightforward that an otherwise law-abiding citizen can, again, carry their firearm and not be jailed for not having a permit. This section keeps in place those protections so that stalkers, drunk drivers, and those that have been, again, declared involuntarily committed, they are currently prohibited from being able to carry. That we keep that in the statutes, but it would put it over in the criminal code where it really should be. I mean, that should not be a part of someone's preserving the other portion of this bill that preserves someone's constitutional rights. That should be part of the criminal code that is completely separate from that section of the bill. So it does not either increase or decrease the penalties that are out there currently. It merely keeps those in place for individuals that are currently prohibited from being able to get a carry permit.
Thank you, Leader Lambert, for the explanation of the amendment. I have Representative Griffey on my list.
Thank you, Mr. Chairman, and thank you, Leader Lamb, for bringing this legislation. While I philosophically don't really support this amendment, I want the governor's bill and the entire House to have the ability to review this bill and legislation as the governor would like it. So I just want to go on record. I'm not in favor of the amendment, but I want this bill. I am a co-signer on the governor's legislation, so I just want to state that. Thank you very much, Mr. Chairman. Thank you, Leader Lambert.
Thank you, sir. Any other questions on the amendment? Representative Hardaway, you recognized? Oh, I'm sorry. Leader Lambert's name was called, and he has the right to speak.
Thank you, Mr. Chairman. I merely wanted to say thank you for your support of both this amendment and the bill. And I know we share the same goals of increasing freedom and keeping our communities safe. So thank you for that.
Thank you, sir. Absolutely. Next on the list is Representative Hardaway.
Just put me on the bill, Mr. Chairman, if you would.
On the discussion of the bill, yes, sir. We'll save your remarks for then. All those in favor of adopting amendment coded 4089, please signify by saying aye.
Aye.
Those opposed, you adopt. Now I would make a motion to roll amendment number 1 and amendment number 2 into one. I've got a motion and a second. All those in favor say aye. Those opposed, you roll into one. Members, we are now on the bill as amended, House Bill 786. Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. To the sponsor, how will reciprocity with other permitless or constitutional carry states work?
Leader Lambert, you're recognized.
Thank you, Mr. Chairman. Exactly the way it does now, and thank you for asking that question. If you have a permit, again, the state of Tennessee will keep our permitting process in place. If you have the enhanced carry permit, there are two different types of permits right now. But if you have the enhanced carry permit, then that would have reciprocity with the same states that it does currently.
Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. So I'll use Mississippi as an example. For them to carry in Tennessee, can they do it without a permit, or would it be, if they're a Mississippi resident, would it require them to have a permit?
Leader Lambert.
Any otherwise law-abiding citizen that is here, so any American citizen that happens to be present in Tennessee, regardless of where they reside, would not be jailed for not having a permit. And so we're taking off the criminal penalties for those that fall outside of, again, the other prohibitions. I mean, convicted felons, Those that have been mentally committed, illegal aliens, convicted stalkers, or drunk drivers, they would not be able to exercise this right, just like they are not able to right now. But otherwise, law-abiding citizens from any state could carry without the threat of incurring jail time simply for exercising their Second Amendment right.
Thank you, Mr. Chairman. Thank you, sponsor.
Thank you, Representative Hardaway. Next on my list, I have Representative Lamar. Representative Lamar, you're recognized.
Thank you, Mr. Chairman. Under current law, to get a permit, you have to undergo a background test and take some training in order to get a permit to carry a gun all the time. And you'll be taking this away. So how will law enforcement be able to distinguish between individuals prohibited from carrying a gun under federal state laws and those carrying legally if you don't have the background check process?
Leader Lamberth?
Again, to be clear, we're not taking anything away from that process. The exact permit process will still exist that exists out there right now, and law enforcement will do the same thing they do now. If they have reasonable suspicion to investigate whether or not someone is carrying a gun, it'd be the same as if when they stop a vehicle right now. So in a vehicle, you're not required to have a permit to have a gun in your vehicle. So when law enforcement stops someone in a vehicle, they look for any indicators that that person may be a convicted felon, they may have mental health issues, they may be intoxicated, and they investigate that potential crime. All of those crimes exist, and in fact, in this bill as amended, we are significantly increasing the penalties for those that are, those that steal firearms, those that are felons in possession of firearms, those that, commit violent crimes with firearms. We're actually increasing those penalties. So it would be just as it is right now that law enforcement investigate those just as they do currently.
Representative Lamar.
Absolutely, and I understand that. But say, for example, if I am a felon and I'm walking to the corner store with my gun on my hip, not committing any crime, and I know I'm not supposed to have a gun, how can law enforcement stop me from carrying a gun if they can't? If I'm not committing a crime and I got this firearm and it's constitutional carry, anybody can carry it. How would they know that I'm not supposed to have that gun?
Leader Lamberth.
The same way they would now. Law enforcement shouldn't be just stopping anybody they want to and shaking them down for whatever reason. That's wrong. That is an absolute wrong thing. That's a stop and frisk that I know I've heard you, or at least I think I've heard you speak against that in the past, where you should not be stopping people just because you don't like the way they look or who they are or where they are. You've got to have reasonable suspicion. You've got to have probable cause. You've got to have a reason to stop somebody and investigate them. You can't just, law enforcement should not be stopping someone and just shaking them down because they feel like it. That should never happen.
What I'm saying is, if I'm walking down the street with a gun,
Lamar, you're recognized.
I apologize, Chairman. What I'm saying is, if you have to get a permit to carry a gun around anyway, you go through that background process. While you saying you're not taking this process away, which is fine, but if we pass this bill, anybody can carry a gun without going through that permit process. Am I right?
Leader Lamberth.
No, you're not. The same list of people that can't carry a gun now would not be able to carry after this. We're taking the criminal penalty off. If an otherwise law-abiding citizen who is eligible for a permit doesn't get that permit, they're just not going to go to jail now. But again, the permit process is still there. All the prohibited individuals that could not carry now is still there in law, and they would face jail time, in fact, increased jail time. None of that changes. And the process for law enforcement to investigate a crime, that doesn't change either.
Representative Lamar.
I will highly disagree. I'm saying that if someone doesn't have to go through the permit process, regardless they can have that gun or not. If right now, if someone's walking around with a gun and an officer sees you, you can present your permit and say, I'm lawful. But if we push this bill and someone's walking with a gun, you can't necessarily ask them, and they could be a felon. So you're allowing felons to walk around with guns easier with this bill because individuals can walk around without going through that whole background check process and have guns on them. So you're giving, while felons aren't supposed to have it, I understand that. But what I'm saying is, a felon can walk down the street with a gun and you can't say anything to them.
Leader Lamberth.
No, again, that's a fundamental misunderstanding of how this process works. if they believe that a crime is being committed or if that person is a felon, I mean, they're going to have to build in some sort of reasonable suspicion to stop that person. A law enforcement officer can't just stop anybody they want to and shake them down. You can't do that. I mean, that's against your
I
constitutional
get that.
rights.
I'm not saying that.
Representative
hang on.
Lamar, you recognize?
So, I mean, they're going to have some reason to actually interact with that citizen, okay? If they believe a crime is being committed, they can investigate that. They can run their record. The mere presence of a physical card saying someone is a carry permit holder should never be good enough to indicate that they're not a convicted felon. I mean, that card could have been revoked in the system. That person could have been convicted the week before. If they have reason to believe, they have reasonable suspicion that a crime has been committed, they should investigate that. I mean, do their job, investigate that incident, but leave lawful citizens alone. Don't just shake people down for whatever reason. I must have made an assumption based on our previous conversations. I thought you were against law enforcement just stopping people for no reason whatsoever and shaking them down just to try to invent a crime to be able to charge them with. I mean, that's what we're prohibiting here. You can't just stop anybody you want to just to check them out. I mean, you've got to have a reason to investigate that person. And then just because they have a permit on them, whether this bill were to pass or not, you should never just assume that that permit is valid. You should still check the database, see if they've been convicted, see, try to figure out if there's any kind of mental health issues, if they're intoxicated. Even a permit holder, if intoxicated, cannot carry that gun. That's illegal, both under this bill and under current law. So again, the mere presence of a permit is not like some get-out-of-jail-free card to, all of the criminal penalties that are in the statute. If someone's committed a crime or doing something wrong, the officer needs to investigate it.
Representative Lamar, do you wish to be recognized?
Yes, thank you.
recognized.
That's not what I'm saying is giving law enforcement the position to shake people down. What I'm saying is you're going to create a loophole for more felons to be able to carry guns without the check and balances of the system. That is the point that I'm trying to emphasize with this bill. But I'll move on to my next question or my next comment. While I understand, and I'm a big supporter of our Second Amendment rights to carry guns, and I encourage all citizens to get their gun license or possess firearms, I find it interesting that we put so many barriers on other constitutional rights like voting, being able to travel, and we're lessening the constitutional rights or process for something like a gun that can easily kill somebody, but we're heightening the processes for other constitutional rights like voting. So I don't think it's right that, you got law enforcement who we claim to support are asking you not to push this bill because of how it would endanger the community, especially the Memphis community, when our police director has asked not to put this in place, our city mayor has asked, because it will increase crime in my city. So I just wanted to put that comment out there. You don't have to respond to it, but I just wanted to make sure I said that on the record.
Leader Lamberth, you're recognized if you wish to follow up.
And thank you for your comments. And yes, I pretty much do have to respond. It absolutely isn't a loophole in no way, shape, form, or fashion. It takes off the criminal penalty on someone who has literally done nothing wrong in their life. They've not been convicted of a crime. They've not been mentally committed. There's nothing wrong at anything they've done. They've not been convicted of anything, and they're only exercising their Second Amendment rights that they could already do in their house, their business. I mean, these are the group of individuals we're talking about. They can exercise their Second Amendment rights and have that firearm in their house, their business, their friend's house and business, their boat, their car, their bicycle, their motorcycle. Literally, we criminalize those folks unless they get a permit if they're walking to and from those locations. We're just taking the criminal penalty off, and I know there are a lot of my friends that will say they support the Second Amendment, and I take you at your word that you do. This is the chance to actually prove it. I mean, this improves Second Amendment rights while also improving community safety. So that's what we're talking about, and we may differ on how to get there, but that should be the goal, I would hope, of all of us, is increase liberty and improve community safety. That's the goal of the bill.
Last question, Mr. Chairman.
You're recognized.
So if I don't have to go through the process, how can we ensure that people who actually own guns know how to use guns, that they don't know how to go through that they don't have to go through the training anymore?
Leader Lamberth?
The exact same way that we do right now. I mean, there's no difference. I mean, again, the only thing you have to go through to get a permit is a one-time class. To pretend that somehow or another that immediately makes you safe to carry a gun is a fantasy. That is ridiculous. So people should go through regular training if you own a firearm. Absolutely, go practice with that gun on a regular basis. Do what law enforcement and other folks that carry on a regular basis do. Familiarize yourself with that weapon. There's nothing in the Second Amendment that requires that, but that's what you should be doing. That's exactly what you should be doing right now.
Next on my list, I've got a number of folks on the list, so I've seen your wave at me. Next on my list, I have Chairman Farmer. You're recognized.
Yeah, thank you, Mr. Chairman. And to Leader Lambert, I think, based off the conversation I just heard, I think there's some confusion about how are we changing how a person obtains a firearm. When you go in to purchase a firearm, are we allowing felons to come in and purchase firearms from Bass Pro Shop now? Talk a little bit about that, because I think that's important to understand.
Leader Lambert.
Thank you, Mr. Chairman. I think your staff tried to recognize me, but I've been told over and over again I have to get recognized by the chairman. So nothing changes again. I mean, the background check that's in place right now is still in place. I mean, every firearms dealer is still going to have to check a background. And in fact, all the protections that are in the law right now are going to be improved. I mean, if somebody steals a firearm under this law, which if this were to pass, if someone steals a firearm, which creates most of the danger that's out there, it's guns that are stolen out of cars or businesses or homes, and that's a misdemeanor in a lot of instances because of the value of the gun is under $1,000. And I know, Chairman Farmer, you know that better than anyone in your practice and in your years down here in the legislature. This makes it a felony. If somebody steals a gun, it's going to be a felony if this passes with a 180-day mandatory minimum. So if you steal a gun, I hope you like jail because you're going to see a whole lot of it if you steal a gun if this law passes.
Thank you, sir. Next on the list, I have Representative Griffey. You're recognized.
Thank you, Mr. Chairman. And to the earlier questions regarding being able to determine whether somebody has a gun on them and whether the police can stop them, reasonable minds may differ, but under our current law, the police have to have reasonable suspicion that a person is presently engaged in criminal conduct or appears to be maybe attempting to engage in reasonable conduct. And just because a person has a firearm on their person, they may have a permit, they may not. Reasonable suspicion is not supported by a 50-50 guess one way or another. So the police are going to have to develop more than just, I saw a person that had a gun on them, to stop somebody. Now, I'm not saying that doesn't occur in real world situations, but I think most judges would tell you need more than just, I saw a person with a gun, he may or may not have a permit to be able to stop somebody. So we're not like communist China. Unless you've engaged in something or you're doing something that draws law enforcement suspicion that you may be engaging in criminal conduct or something like that, that's when they have a basis to stop and check you. And this legislation really wouldn't change any of that. So thank you.
Thank you, sir. Next on my list, I have, and by the way, we have two people here to testify. So I've got two more folks on the list, and then we'll go to testimony. Next on the list, I have Representative Beck. You're recognized.
Thank you, Mr. Chairman. I've filed a amendment draft code 4575. Are we going to take that up?
Are you moving that amendment, sir?
I'm moving that amendment.
Representative Beck moves amendment coded 4575. Do we have a motion? We have a motion and a second. Excuse me. He motioned his own amendment, and we have a second.
I didn't motion it.
Yes, you did, by bringing it up.
Oh, by bringing it up,
yes. Yes, sir. Yes, sir. So you are recognized on amendment coded 4575.
Great, thank you. Committee, I have dove into this in a head-first way and had a lot of discussion with Leader Lambert during when this was in front of Sub. And we had a lot of testimony in front of Sub from law enforcement, and I just got a letter sent to me from the Tennessee Association of Chiefs of Police from a chief where they are against this. The chiefs of police are against it. Former commissioner of safety is against it. The sheriffs testified that they're against it, and the TBI testified that they're against it for many different reasons. A lot of them I won't rehash from Sub. And then I looked at, I keep hearing that people are jumping up and down for this. And I looked at the polls, and the question on the latest poll, Governor Lee said in his speech he would move forward with legislation allowing people to carry a handgun without a permit. Regarding such a proposal, are you? And 84.4% of Tennesseans said they were opposed. Only 11.9% of Tennesseans agreed with this. And then I looked at another poll that asked the question, under Tennessee law, people are required to get a permit. Do you support this? And overwhelmingly, either strongly support or support, 93% of the people in Tennessee supported our permit process. Then I looked at the permit process itself. And in 2008, there were 62,185 handgun permits. In 2018, there were 189,674 permits issued that year. 1,900 permits were suspended. That means they did something wrong. And 931 were revoked. And 2,616 were denied. Ladies and gentlemen, that's over 4,000 people who either violated the laws of the permit or were denied getting the permit for some mental, criminal reason. We then went forward, and what I thought is, I understand from discussions in sub and other things that many people feel that the cost of the permit hinders people or presents a barrier to their ability to carry a gun. Well, in the legislation that is before us, the governor has put in his budget the money to do away with the permits. So why don't we have a happy coming together here and say we do away with the cost of the permit, but not the permit. Then we keep, number one, the people who should not have carrying a gun in public would not be able to get their permit, but the ones that are the 189,000 more now, would not have to ever pay a fee. So there's no obstruction with them going forward having a permit, and thus no barrier to this constitutional right carrying the permit. It's a minor infringement upon total wild, wild west in order to keep people safe. And as you can see from the polls, people want to be kept safe. They feel like they are safe with the situation as it stands now. So we are here to do the will of the people. The will of the people says they like this permitting process. The law enforcement, who we all stand up and beat our chest and say we back the blue, say they are against it wholeheartedly. It's not that we have one section of the state saying we're against it and the other section saying we're for it. We have every law enforcement agency saying they are against doing away with permitted carry. And I've listened to the sponsors' reasons why this isn't correct, et cetera. But you can't tell me as we sit here today that all law enforcement is wrong and that one sponsor of a bill is correct and that we cannot be safe for our police and our people in uniform with doing away with any type of permit. So, Mr. Chairman, I would move that drafting code 4575 be put on the bill to allow permits to stand, education to stand, background checks to stand, all applicable eligibility to obtain a permit stand, except the cost. Let's give the people their permits. Let's do away with that stumbling block. Let's keep our policemen safe, and let's yield to the will of the people of Tennessee and keep our permitting system. I thank you very much, and I move my amendment.
Thank you, Representative Beck. Representative Beck moves his amendment. First up for questioning, I have Vice Chairman Russell. You're recognized, sir.
Thank you, Mr. Chairman. Question on amendment.
Question's been called on the amendment. Without objection, we're ready to vote. All those in favor of adopting amendment coded 4575 to House Bill 786, please signify by saying aye.
Aye.
Those opposed? No. The amendment fails. Next on the list, I have Representative Dixie. Representative Dixie, you're recognized.
All right, thank you. I got a couple questions and a couple statements. One is, I think that we've seen, especially since I've been here the last 3 years, that we've increased a lot of penalties with crimes and in the code, and we've done that over the years, but crime hasn't gone down. So I don't think that increasing the penalties and crimes is going to have the desired effect that the law enforcement want, is to get guns off the streets. And I think the goal is to get guns off the streets. I'm not really sure, because I've got a couple different answers, but Mr. Sponsor, you could help me out with this. What is the fiscal note on this?
Leader Lamberth, you recognize.
Thank you, sir. The total fiscal impact, there are several different amendments here, and I think the total increase of state expenditures is just over $12 million. That's on the increased penalties. And to your question directly, I sounded like two different questions, is, what do increased penalties mean as far as reducing crime? I can guarantee you this, for the 6 months that some thief that steals a firearm that's trying to put that out there in some felon's hands, they're not committing any crimes during that 6 months. And so that's a guaranteed 0% of recidivism while they're serving time in jail or prison for committing these type of violent crimes.
Representative Dixie, you recognized.
I would like to say, I think earlier when you and another representative were talking, you said that, you can keep guns in your cars, boats, houses, things of that nature. But you can't, it would cause a penalty currently if you're walking back and forth with it. I think the reason for having those castle doctrines is that if you were to get upset, at least you have time to cool down before you get to it, or think about what you're about to do. If I have a firearm on my hip now and I get into an altercation, I may take someone's life. Our law enforcement do a great job of training, and they still struggle with the split-second decision of having to take someone's life. We're asking untrained people that anybody can get a firearm, they can legally carry a firearm, to put themselves in that same position of taking someone's lives with no training. And I think this bill will encourage, it may take some people off the street for 6 months, but it also have some people doing multiple 10s and 20 years in jail, maybe even life. So it's not going to be, I just don't see how the increase of penalties will be a deterrent for this crime. And I think that also with the price tag of this bill, I think that there's other ways the state could spend this money, especially when we're struggling to pay our teachers. Thank you, Mr. Speaker. Mr. Chairman, I don't have any other questions.
Thank you. Next on my list, I have Representative Lamar. Are you recognized?
Thank you, Mr. Chairman. I would like to be recognized on my amendment.
Representative Lamar, I see amendment coded 4522. You wish to move that?
Yes, sir.
Representative Lamar moves her amendment. Do we have a second?
Second.
Ma'am, you have a motion and a second. You're properly recognized before this committee.
Absolutely. Well, my amendment would exclude the 4 major cities, Memphis, Nashville, Knoxville, and Chattanooga, from this bill. Now I move my amendment.
Members, you've heard the explanation of the amendment. First on the list, I have Chairman Doggett. You're recognized, sir. Question's been called on the amendment. Without objection, we're ready to vote. All those in favor of adopting amendment coded 4552 to House Bill 786, please signify by saying aye. Aye. Those opposed? No. Noes have it. The amendment fails. Next on the list, I have Representative Hardaway. Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. I'm going to ask those noes to turn down the volume when it comes time to vote for my amendment. Mr. Chairman, I'm going to call up amendment number 004553. And it quite simple.
Representative Hardaway moves amendment coded 4553. Do we have a second? We have a motion and a second. Sir, you're recognized before the committee.
Thank you, Mr. Chairman. And to the sponsor, it merely takes Memphis out of the bill. Our sheriff for Shelby County, Sheriff Bonner, our police director, Mike Rollins, every officer and every sheriff's deputy that I've spoken to is fearful that should this pass, and we have constitutional or permitless carry. I understand there's a difference between the two depending upon who you ask, but they are fearful that there will be more street violence, there will be more accidental shootings, there will be more suicides. There will be more thefts from cars, and I think the sponsor recognized that eventuality because we've increased in the same bill the penalties for thefts from cars. And we know that those guns find their way into criminal activity. And with that, Mr. Chairman, barring any questions.
Thank you, Representative Hardaway,
for
the explanation of the amendment. First on my list, I have Representative Griffey. You're recognized. Question's been called on the amendment. Without objection, we're ready to vote. All those in favor of attaching amendment coded 4553 to House Bill 786, please signify by saying aye.
Aye.
Those opposed? No. Sorry, sir, the amendment fails.
Thank you for toning that down a little.
Thank you, sir. Members, I have no one else on my list. Representative Dixie, you wish to be recognized? You're recognized.
Yes, I would like to be heard on my amendment, which is 004556.
Parliamentary procedure we find ourselves in as Representative Dixie has moved his amendment coded 4556. You have a second. Sir, you're properly recognized.
This amendment, it just moves the effective date back 1 year to allow people who really would like to have some training to get time to get some training.
Members, you've heard the explanation. First on my list, I have Representative Campbell. You're recognized.
Previous question on the amendment.
Representative Campbell moves previous question. Without objection, we're ready to vote. All those in favor of attaching amendment coded 4556 to House Bill 786, please signify by saying aye.
Aye.
Those opposed? No. Sorry, the noes have it. Amendment fails. Members, there's no one else on the list, so without objection, we're ready to vote. I'm sorry, Vice Chairman Sexton, you're recognized, sir.
Thank you, Chairman Curcio. I'll make it quick. I just wanted to ask Leader Lambert if he's familiar with the First Amendment of our Constitution, freedom of speech.
Leader Lambert, you recognized? Yes, sir. Vice Chairman Sexton.
Do you have to have a certificate to freely speak?
Leader Lambert?
No, sir.
I'm
Chairman
sure you're, thank you, Chairman. And so you're familiar with the Second Amendment that says that we have the right to keep and bear arms, and this right shall not be infringed upon. Is that correct?
Leader Lambert?
Yes, sir.
Vice Chairman Sexton.
Thank you, Chairman. So it's your position that we should not have to have a certificate to carry a firearm, according to our Second Amendment rights. Is that correct?
Leader Lambert.
So in this bill, again, we preserve someone's ability to be able to get a permit if they so choose. We encourage anyone to go through regular training with their firearm and learn proper storage, proper usage, how to safely utilize that firearm. But we're not going to jail someone for exercising their constitutional rights. There's nothing in the Second Amendment that says exercising your Second Amendment rights should be a criminal act. And so we are taking that criminal act out of the law and ensuring that you do not have to have the government's permission to exercise your Second Amendment right.
Vice Chairman Sexton.
One last question. So by this, you're saying that it doesn't matter if all the law enforcement in the United States was against this, we still, according to the Second Amendment, have the right, regardless of what law enforcement or anyone else says, according to our Second Amendment rights, we do not have to have a certificate.
Leader Lambert.
So the entire British Empire was pretty opposed to the Second Amendment when it was brought to us by our founders, and yet it still made it into the rights that we have enshrined within the Constitution and the Bill of Rights. So yes, sir, no matter who is opposed, this is an improvement on our freedoms, and it preserves those Second Amendment rights.
Thank you.
Vice Chairman Sexton.
Thank you, Leader Lambert. That was well said, and I am 100% behind your bill, and I'm proud that you're bringing it.
Thank you, Vice Chairman. Members, we do have two folks on our list to testify. So if there's no other questions for the sponsor before that, Representative Hardaway, you wish to be recognized?
Yes, sir. And the Vice Chair kind of brought this to mind. I want to make sure I understand whether the language in this bill speaks to all firearms or whether some firearms will still require a certificate. I believe that's the way the Vice Chair put it.
Leader Lambert, you recognize.
This particular piece of legislation, there's another piece of legislation you may be asking about, but this one involves individuals that are over 21 and involves handguns.
Representative Hardaway for follow-up.
Yes, sir. I just want to make sure I understand there's a distinction. When you say firearms, there's a distinction between handguns and long guns. This legislation applies to handguns.
Leader Lambert.
Yes, sir, it is. I will say there is not a distinction in the Second Amendment. There is a distinction in this particular bill, and this is the biggest bite of freedom we can get at one chomp.
All right. Thank you, sponsor. Thank you, Mr. Chairman.
Thank you, Representative Hardaway. Representative Beck, you're recognized.
Thank you, Mr. Sponsor. Does this change in any way you brought a bill several years ago about where you could carry and the metal detectors in public buildings and that type of thing, and the posting of businesses? Does any of this change under your bill today?
Leader Lambert.
No, it does not, but I appreciate you bringing that bill up. I felt that it was a very good piece of legislation. I was glad to see it become law. It significantly reduced the number of gun-free zones out there and ensured that if you're going to prohibit someone from exercising their Second Amendment right and carrying their firearm to defend themselves, then the entity prohibiting that is actually making sure that no one else has a firearm in there either. Before that bill, it just posted a sign, and that's all it was. After the bill, you had to have someone that was doing a bag check and metal detectors, and nothing in this bill changes any of that, but it too hopefully was a step forward.
Okay, very good. And
Representative Beck, you're recognized.
Oh, thank you, Mr. Chairman. I apologize. And to the sponsor, you were just answering the representative from Granger about the first and our freedom to speak. Have you ever known anybody to get talked to death?
Leader Lambert, you're recognized. Okay. Without anyone else on the list, we We are going out of session to hear testimony. Members, if we could, try to keep it together here. We're going to go out of session. First on our list, we have Dr. Jill Streams. Is Dr. Streams in the audience? Ma'am, the rules of engagement here are make sure your microphone is on, if you don't mind. There's a red button. There's a picture of a voice. It looks like there's, got it. If you could just introduce yourself to the committee and then share with us whatever you'd like, and you have 3 minutes to do so. There will be unlimited time for questions and answers.
Certainly. Good afternoon. Thank you to the committee for the opportunity to provide this statement. My name is Dr. Jill Streams. I'm a trauma surgeon at Vanderbilt University Medical Center. Just want to make clear that I am here in my personal capacity, not on behalf of Vanderbilt. My testimony today is based on 12 years of experience in the medical field, and I'm here to urge you to strongly oppose House Bill 786, both as a citizen of Tennessee and as a trauma surgeon who cares for patients with injuries due to firearms. 2020 has been a hard year for our entire country. Over 11,000 Tennesseans died from COVID, and let me tell you that myself, other doctors, nurses, healthcare workers have had a hard year. But what you may not know is that 2020 has also been a banner year for gun deaths and injuries due to firearms. In 2020, in Davidson County alone, gun deaths and injuries increased a staggering 31% over 2019. That far outpaced the increase in Davidson County population, and we have seen for the first time ever, over 500 events of gun violence. Excuse me. The volume of trauma patients at Vanderbilt has been the highest ever recorded in 2020. Frankly speaking, we are drowning in gun violence. Trauma centers across Tennessee are also seeing the same increases in trauma patients. And year to date in 2021, our incidences of homicide due to gun violence in in Davidson County are up 55% just in the first 2+ months of the year. So the data is clear and unambiguous. We have a problem with gun violence in Tennessee. The economic burden of that is it costs our state over $9 billion each year due to gun violence, and $400 million of that is from taxpayer money. So firearm injuries affect all segments of our population. As we all know, a nurse was shot and killed on 440 several months ago on her way to work. Just last week, a local man was shot and severely injured at his place of business. A grandfather was shot protecting his grandchildren. Now, my trauma team is exceptionally good at what we do, but unfortunately, we cannot save everyone, and there are far too many patients that die from gun violence. I'll tell you, there is no worse sound in the world than the wail of a parent when I tell them that their child has died. It is a sound that is imprinted on your soul, and I have to have that conversation far too often in my career as a trauma surgeon. Increasing access to firearms with the passage of this bill with permitless carry will absolutely increase the number of firearm injuries and deaths in Tennessee. I ask you to preserve the well-regulated phrase of the Second Amendment and ensure that gun owners still have their Second Amendment rights, but are properly vetted and permitted the same way that I am required to be licensed to practice medicine. So I'm here today to ask you to please heed the advice of the experts who have come out against this bill, including our law enforcement agencies. And I recommend against the passage of this bill. It will make my job harder, it will make law enforcement jobs harder, and more Tennesseans will die.
Thank you, ma'am.
Thank you.
Members, any questions for our witness? Representative Hardaway, you recognized.
Thank you, Mr. Chairman, and thank you, ma'am, for the work you do. And I know there's a lot of stress involved with your work. In fact, I wanted to ask you about the COVID-19 stress and the potential to have an increase, should this bill pass and become law, to have an increase in incidents of accidental shootings and suicides.
Yes, the data is very
Ma'am,
clear. Excuse me, thank you, Chairman. No problem. Yes, the data is very clear that increasing access to firearms in our homes increases the number of accidental injuries, increases the number of children that get a hold of these weapons that are improperly stored, and increases the number of suicides. Essentially, if you have ease of access to means and you have the motivation, you're going to increase suicides. And that data is very, very clear.
Representative Hardaway for follow-up.
Thank you, Mr. Chairman. And to interpret what you just said, the more guns, the more violence, the more gun injuries and gun deaths. And I'm going to rephrase what you said when you first came up. You said we were drowning in gun violence. We're actually drowning in the blood of gun violence victims.
Dr. Streams, you wish to respond?
Yes, sir, that is correct. I wash blood off my shoes after every shift.
No more questions, Mr. Chairman.
Thank you, Representative
ma'am.
Hardaway. Next on the list, I have Representative Halsey. Chairman Halsey, you're recognized.
Thank you, and thanks, Doctor, for being here. Let me ask you a question. Can you tell me again the total number of gun deaths that you gave? Was that in Nashville in 2020? And of those, how many were those of those were suicides?
Dr. Streams, you're recognized.
So I can't give you all that exact number in terms of the breakdown between homicides and injuries and suicides because that data isn't tabulated for my purview. That data is taken directly from CompStat for Davidson County. There were 524 incidences of death and firearm injury in 2020 in Davidson County proper.
Chairman Halsey, any further questions? Thank you, sir. Thank you very much for being here, ma'am. We all appreciate the work that you do for the state of Tennessee and for in your role. So thank you.
Thank you all.
Absolutely. Members, next on the list, we have Mr. David Botkin. Mr. Botkin is here. Sir, same rules apply. If you could introduce yourself to the committee, share with us whatever you would like. You've got 3 minutes, unlimited time for question and answer. And I forgot to say before, but everyone will just get recognized through the chair, and that just keeps us from having like a running debate or a back and forth. So you're recognized, sir. Yes, sir. Is that red light on in the microphone?
Yes, sir.
Okay, perfect. If you could just state your name for the record and then
Yes.
share with this committee wherever you'd like.
My name is David Botkin. I work in the firearms industry, but this is an area of concern for me that long predates that. First off, I'd like to thank you all for having me, and I'd also like to thank the governor for promoting this bill. I think it's a really good move, and of the 18 states that have constitutional carry right now, a lot of them have not had their governor on board with the push to make that law. Now, I know that you've all spent a lot of time working on this law and discussing it and different aspects to it, but one aspect that I don't know has been brought up yet is the origin of the current laws that Tennessee has regarding the regulation of carry of weapons, and that's what I'd like to talk about, this concept of the point of origin. If we look back through Tennessee's history in 1835, the Article 26 of the Declaration of Rights only protected the rights of free white men to keep and bear arms. Also in that same year, a law was passed banning the transfer of weapons to slaves unless they had the permission of their masters to receive those. In 1870, the Civil War was over, Reconstruction was over. Tennessee amended their constitution. They were no longer allowed to have this radically discriminatory law. But in changing their constitution to allow citizens to have this right, they then banned carry across the board. And they just banned it completely. And they updated the law over the years, adding new weapons and things like that. For example, our ban on brass knuckles dates to 1879. Now, the problem is, looking through this, it appears that the driving motive behind these bans was an attempt to keep weapons out of the hands of recently freed black slaves. I have here 2 legal reviews, one from Chicago Kent College of Law and one from George Mason University. One's called Gun Control and Racism. The other is called Never Intended to be Applied to the White Population. And basically what they argue is the common practice in the South after the Civil War was to totally ban the carry of firearms, and in some cases the ownership, in some cases the ability to buy them, and then only selectively apply that law to blacks. And the title of this second one I just mentioned comes from a legal case in 1941 in Florida, where the conclusion was, quote, the statute was never intended to be applied to the white population, and it goes on from there. So as we discuss this and as we discuss making changes to this law, I think it's important that we think all the way back to where these laws came from, why they were put on the books, and maybe we need more than just some tweaks. Maybe we need some more radical overhauls. As I was researching this, I was reminded of a quote. It says, history shows that all conquerors who have allowed their subject races to carry arms have prepared their own downfall by so doing. That quote is by Adolf Hitler. We can find this sentiment throughout history where the powerful have tried to subjugate the weak. And that's our concern with Tennessee's origins in this law, is that was the motive, to lord it over the poor. In Matthew 20, Jesus says, "You know, the rulers of the Gentiles lord it over them, and their great ones exercise authority over them. It shall not be so among you."
Thank you, sir. I didn't want to interrupt Holy Scripture, but that is the end of your 3 minutes, but you've got an unlimited time for questions. Any questions for our witness, Representative Griffey? You recognized?
Thank you, Mr. Chairman, and thank you, Mr. Bodkins, for sharing that history and painful part of Tennessee history. But I'm proud to sponsor this legislation so maybe we can redress some of the wrongs and sins that have been committed by our forefathers, and let every man, woman, and every legal person in Tennessee that's required to possess and carry a firearm for self-protection. And to Dr. Stream's comments, I know it's extremely upsetting. We appreciate her being here, but the laws that we have on the books now, we're in this situation. There's 18 other states that have passed constitutional carry. Not one of those states, it's my understanding, has gone back and amended to change it, saying, "No, this is we're having more crime. We're going to have to change what we did." Are you familiar with that history or not? Thank you, Mr. Chairman.
Mr. Botkin, you wish to respond?
I'm not aware of any states that have gone back on their expansion of the rights to carry.
Thank you, sir. Next on the list, I have Representative Hardaway. You're recognized.
Thank you, Mr. Chairman, and good afternoon, sir. I certainly appreciate your scholarship and being able to go back and trace the history. And of course, when you talk about black folks, I feel like I need to get a word in. The thing that I would like to see, if we're going to involve ourselves with the reforms that apply to this particular part of the Constitution, then I would like to see us simultaneously look at the equality issues in terms of how the law applies to black folks under the Constitution, and equity in the actual judicial equity and how those laws are applied. And I don't see that. We're not at that point, which just heightens my concern for putting more weapons in more hands without addressing those issues of equality and equity. I suspect, and I'll be happy to see all of my colleagues back here at the same time next year, that we're going to find that the numbers are going to show that more black folks are going to be charged, and more black folks are going to be charged and convicted of crimes with more severe sentencing. That's anecdotal at this point, but it's based upon the same thing that you cited, history and statistics. So I'll leave it at that.
Thank you, Representative Hardaway. Next on my list, I have Representative Dixie. You're recognized.
I think Representative behind me, he referenced, and you said that there was I think you referenced it, there was 18 states that have open carry, and they haven't gone back. Out of those 18 states, how has their crime increased over time, or has it stayed the same or gone down?
Mr. Botkin, you're recognized.
So it appears that what's happened is when you look at crime charts, with the rise of carry permits and the explosion of the number of carry permits, last I checked, there's about 18 million issued carry permits in the U.S. Violent crime has taken a dive almost consistent with the rise in the number of carry permits. And it appears that as states have gone to constitutional carry, that trend has not reversed. There will always be people that carry illegally and use firearms improperly. It doesn't appear to be that this is really changing that or increasing that number. I haven't studied it extensively, just the amount I've looked into it doesn't seem to change it.
Representative Dixie, you recognized.
Well, I just did just a little digging, I was just curious. In Arizona, since they enacted in 2010, annually, the rise has been 8% in aggravated assaults with a gun. In Alaska, since they have enacted in 2003, its rise has been 65% of aggravated assaults with a gun. So my point is saying that it's not a deterrent. Crime still increases, and I think that it gives them the opportunity to commit a crime of emotion if they have a handgun on them or out of need. Because right now we're in a pandemic and people are struggling right now, and they're not getting the resources they need to survive.
Thank you, Rep. Oh, sorry. I thought you were finished.
No,
Go ahead,
no.
sir.
I was just going to just ask you that, and I know we didn't get to hear all of your presentation, and it may have addressed it later, but I would definitely want to know those statistics if you were, if it was a longer presentation.
Mr. Botkin, you're recognized.
I would love to go study that. I'm so intrigued by the study I've been doing on the history of Tennessee's laws. That's really where I want to go next. I was literally right before coming into here, I was like, oh, here's a new law. I didn't know about this one. But you're right, that deserves work. It should be looked at, but I don't have the answers at this point.
Thank you, Representative Dixie. Next on my list, I have Representative Lamar. You recognize, ma'am.
Thank you, Mr. Chairman. I would say this was an interesting testimony. I've never heard Jesus, slavery, and Hitler all in one testimony, so that's the first. And I appreciate acknowledging that the foundation of much of our Constitution was discriminatory in its foundation. With this bill, do you think still there will be equity in how we treat those with guns? Do you think that Black people will be treated fairly in their interaction with law enforcement as a white man with the possession of guns?
Mr. Botkin, if you feel you can respond to that.
So it's very hard to answer because I'm answering for all the different individuals that make up law enforcement, but it appears that if we decriminalize possession of carrying a firearm, it's going to remove opportunities for law enforcement to potentially abuse their power and go after people that they have got no business going after. So I would hope that it would move towards a more equitable application of the law. That's my hope.
Representative Lamar.
In your personal opinion, do you think a law enforcement officer who may not be used to interacting with individuals from other communities will be able, if they're fearful, claim to be fearful for their life, they could unnecessarily use deadly force against someone with the gun?
Mr. Botkin.
So this is actually one of the things I hope this is really going to improve, because right now, with the current state of affairs, an officer might approach someone, determine that person shouldn't have a gun, and then they have to go through the sort of surrender process whereby they take that gun from that individual. And it appears that in many law enforcement shootings, it's that interaction where things go sideways, and sometimes the individual with the gun that's having their gun taken doesn't handle it very well. Sometimes law enforcement gives a series of commands: put your hands up, don't move, drop the gun, and there's no way for them to comply with all of them simultaneously. It's very stressful. You recognize that. My hope is that by making it so it's no longer a crime for a bunch of these people, the number of those interactions where cops are disarming people will happen, it'll happen less frequently, and therefore there'll be fewer opportunities for those potential deadly encounters.
Representative Lamar, you're recognized.
Thank you so much, Mr. Chairman. So you're saying the age where we're seeing police innocently shoot a lot of individuals based on the assumption that they may have a weapon, not even verified, that you think if we bring constitutional carry or open carry, or whatever we want to call it, that the number of people shot because they are believed to have had a weapon will go down?
Mr. Botkin, you're recognized.
That is my sincere hope. When we look at constitutional carry or just regular carry before that, there have been a lot of cases where cops see someone carrying a gun, they don't know if they have a permit, they move in to establish contact, and there have been many cases where that has gone very poorly. And then as the law became more broadly understood by state law, local law enforcement, those incidents went down. But there have been countless examples that I've read about where individuals lawfully carrying, even the ones with permits, with the training, still had conflict with those cops. But once things kind of stabilized, once knowledge of the law went out there, those went down. You don't hear about cops coming up behind someone with a gun and just tackling them. But you used to hear about those cases in some states when carry was new.
Representative Lamar, you recognize.
Thank you, Mr. Chairman. And I appreciate your comments, but I can give you countless examples on video of individuals lawfully carrying weapons in their cars or on their persons, and they've been murdered by police. So no, I would have to respectfully disagree with you. But what I will say, I think that advocating for this bill will increase the number of people who die, because in that moment, an officer's gonna think about himself first. And if he's scared, regardless if they're lawfully carrying a weapon or not, they will be shot and they will be die. And what we do know is that black people are oftentimes more on the larger scale of victims of being the ones who die from the hands of law enforcement out of fear from carrying. Philander Castile, lawful gun owner, shot, killed by a police officer at a traffic stop, and he wasn't doing anything. So again, you have countless examples. I have countless examples. You can go on YouTube and find countless examples of how badly things can go if we put this law in place. But thank you so much for coming respectfully, and I thank you for coming.
Members, I have no one else on the list. Mr. Botkin, I would be remiss if I didn't point out the fact that you're a constituent of mine, and I'm glad to have you here in Nashville, so thank you for being here today, sir. And with no other questions, we're ready to go back into session. So thank you, sir. Back in session.
Thank you very much.
Members, we are on House Bill 786 as amended. Representative, next on my list is Representative Howell. Chairman Howell, you're recognized.
Question on the bill.
Question's been called on the bill. Without objection, we're ready to vote. All those in favor of sending House Bill 786 to Finance, as amended to Finance, please signify by saying aye. Aye. Those opposed?
No.
Bill passes. You head to Finance, sir.
Thank you, Mr. Chairman and members of the committee.
Thank you, sir. Next on our list, that brings us to item number 17. Item number 17, that is by Representative Griffey. Sir, you have a motion. Sir, you have a second. You're properly recognized before the committee. I see no amendments.
Thank you, Mr. Chairman. This is House Bill 18. It differs from the governor's version of constitutional carry in the fact that the language is firearms, and it would allow persons 18 years age and older. If you can go off and fight for your country, my opinion is you ought to be able to carry a firearm if you can legally possess it. So that's really the only difference. And I've got 27 members that have co-signed to this bill. I would ask the committee that we pass this, and let's get it to the floor and let the entire General Assembly vote the governor's version, this version. Let's get one of them done. So with that, I'll move for passage.
Members, you've heard the motion. You've heard the explanation. Any questions for the sponsor? Representative Campbell, you're recognized.
Thank you, Mr. Chairman. Previous question.
Previous question's been called. All those in favor of sending House Bill 18 by Representative Griffey to Finance, please signify by saying aye. Aye. Those opposed?
No.
Sir, you head to Finance. Members, that brings us to item number 2. Pardon me, I've misspoken. That brings us to item number 4 by Chairman Ogles. Item number 3 by Chairman Ogles, House Bill 49. Sir, you have a motion and a second, properly recognized. I also see an amendment coded 2687. You wish to move forward with that amendment?
Yes, Chairman. Thank you, members of the committee.
Sir, you have a motion and a second on your amendment. Please explain the amendment.
Thank you, Chairman, members of the committee. This bill changes the submission time from 60 days down to 30 days for sexual evidence to the Tennessee Crime Lab. This bill does not in any way make evidence that's filed outside that time period not admissible for evidence.
Question's been called on the amendment. Without objection, we're ready to vote. All those in favor of attaching amendment coded 2687 to House Bill 49, please signify by saying aye. Aye. Those opposed, you adopt. Sir, we're on the bill as amended. Please explain your bill.
Thank you, Chairman, members of the committee. That makes the bill.
Question's been called on the bill. All those in favor of sending House Bill 49 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman.
Yes, sir. Thank you. That brings us to item number 4, also by Vice Chairman Ogles, House Bill 1343. Sir, you have a motion and a second.
Thank you, Chairman, members of the committee. Presently in Tennessee, it is a crime to smuggle in a cell phone to a penal institution or a prison. But once you get past that barrier to actually have it in the prison or jail, it's not a crime. This makes it a Class C felony. On the first time that you are caught with a cell phone, the judge has discretion on the fine. The second time, you will get the maximum in the sentencing, which is $3,000. That makes the bill. With that, I'll take any questions.
Members, you've heard the explanation. I see Representative Hawk on the list. You're recognized.
Thank you, Mr. Chairman, and thank you. This contraband has been a big issue for decades in the state of Tennessee, so thank you. Who's policing this, Representative Ogles?
Vice Chair Ogles, you recognize.
As far as right now, mostly the Department of Corrections is doing that, and they're here today to speak on this if the committee would like.
Chairman Hawk.
And follow up, just for my information, are they sworn and be able to make that arrest? The correctional officer able to make that arrest?
Vice Chair Ogle.
Chairman, if we may, I'll let them address that more if that's okay, Representative.
Thank you.
Thank you, Vice Chair Ogles.
And someone on the committee may be able to answer that question.
There is a representative here from TDOC. They are also on the list to testify. So, okay. Without objection, we're going to go out of session. We will now hear from Tory Grimes, I believe, from the Tennessee Department of Corrections. Sir, you're well known to this committee, and you know how the microphones work, but if you could state your name for the record and share with this committee whatever you'd like. You have 3 minutes, and then unlimited times for question and answer.
Thank you, Chairman. Tory Grimes, I'm Senior Counsel of the Department of Correction, and also serve as one of the department's legislative liaisons. Specifically to Chairman Hawk's question, this is the interdiction efforts are undertaken by our law enforcement unit. They are sworn agents. They all post-certified agents that are also go to TBI and FBI academies. So those are the folks that usually make these arrests. And we're really interested in this bill. As you all know, this issue has been an issue that's been dear to Commissioner Parker's heart. He has been on the a task force at the federal level for the last 4 years to try to get to a solution nationally for this issue. And if you don't know, cell phones are a problem because they can be as small as the tip of your thumb. They can be hidden anywhere. They can be smuggled in anything possibly unimaginable. And the solution that the department is most interested in is the localized jamming technology, which currently is not available to be used by the states because of an FCC rule dating back to really 1934. So that is the issue that we've been working on at the national level so that state correctional entities can really begin to address this issue. And Chairman Ogle's bill allows us that once it becomes law, it gives us an avenue to take the phone number assigned to that cell phone from the provider. It gives us opportunity to put that phone number on the stolen phone database. And what that means is that phone number is forever blocked from being able to be used again, even though that a lot of times these are burner phones. We think this is a step in the right direction. This is something that we know that we can do in Tennessee, and we're supportive of the bill.
Thank you, Mr. Grimes. Representative Griffey, you recognize?
Thank you, Mr. Chairman. Thank you, Mr. Grimes, for being here. Let me ask this. Is there an exemption or an exception in the bill for law enforcement that might take their cell phone within the Sally port or the checkpoint or maybe the other authorized phone or phone systems within certain penal institutions?
Mr. Grimes, you recognize?
There is a provision. There's a provision in current law where the warden can approve that. That's how it works now. The warden can approve. You're touring a facility. The warden can approve you to come in with your cell phone.
Representative Griffey.
Thank you, Mr. Chair. I've gotten word that some jails may, instead of using the old pay phone on the wall where everybody has to get a number and do that, they've gone to this cell phone thing, click system. So would there be, if the jailer or the sheriff of a local jail is authorizing that click system or something, would it prevent that sheriff from doing that, or could he still do it since he's, quote, the warden of the local jail, or allow it?
That's a good question, and I'm not 100% sure. The bill as proposed uses very similar language that we've looked at in years past, and it makes it to possession, so it's still going to be the DA's, up to DA where they're going to pursue prosecution.
And it's
actually, I was going to say, Representative Griffey, I may jump in because I had the exact same question when we were debating this kind of before we came to committee. It may be clarifying if it would be helpful to you. I think it was helpful to me. We could go out of session and hear from legal. There's some bits in there that made me more comfortable with that exact issue. So without objection, we'll go out of session and hear from Ms. Fogarty. We're already out of session. Now we're doubly out of session. Before we were in the matrix, now we're out of the matrix, but we're out of session. Okay, got it. We're out of service, that's right. Ms. Fogarty, now that we've made all our jokes, you're recognized.
Thank you. This language is adding to subdivision B2, it's adding a subdivision C. The subdivision B2 says that it's knowingly and with unlawful intent for a person to possess. So a person has to, it is unlawful for any person to knowingly and with unlawful intent possess any of the following materials while present. And it's adding the telecommunication device. So they would have to possess it knowingly and with unlawful intent.
Representative Griffey.
And for legal, so then if a sheriff has a paid cell phone system that inmates use a cell phone, that would be an exemption because it would not be unauthorized or unlawful intent.
Ms. Fogarty.
I can tell you that the language is knowingly and with unlawful intent. Okay. So,
thank you. Thank you.
Thank you, sir. Again, I had similar questions, and I thought it might be enlightening to hear that. Any other questions? Representative Dixie, you're on the list for the witness?
Yeah.
Yes, sir. You're recognized.
This bill applies to incarcerated individuals, correct?
Yes.
So what are the penalties, just from my knowledge, for the person who's actually smuggling it in?
Mr. Grimes?
That changed to a D felony last year, a couple years ago. Yeah.
Representative Dixie?
Oh, thank you. I just wanted to know that.
Any other questions for the witness? Seeing none, thank you very much, sir. We appreciate your bringing some clarity to this issue. We are back in session. Members, we're back on House Bill 1343. Thank you. Chairman Doggett, you're recognized. Question's been called on the bill. Without objection, we're ready to vote. All those in favor of sending House Bill 1343 to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman, and thank you for your patience, committee.
Thank you, sir. Thank you for waiting on us. That brings us to item number 9 by Vice Chairman Grills. Sir, you have a motion and a second.
Does is moves farm over to critical infrastructure. Over in my area along the river counties, Representative Moody and I have discussed this before. We have a lot of problem with farm vandalism, from cotton bales being burned to tractors having metal shavings put in their hydraulic tank or in hydraulic reservoirs. I personally have had a trailer truck burnt just sitting in the field. But there's lots of vandalism. For instance, they'll go back up to a pivot, take a truck, hook to the copper wire on it, pull the wire off, take it to a fire, burn the plastic off of it, then they'll sell the copper at a scrapyard for scrap prices, causing the farmer time loss, a headache, aggravation. So what I would like to do is just put this over into critical infrastructure with several other things that have already been protected.
Members, you've heard the explanation of the bill. Any questions for the sponsor? Chairman Russell, you recognized.
Thank you, Mr. Chairman. Question on bill.
Question's been called on the bill. Any objections? Seeing none. All those in favor of sending House Bill 1145 to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Mr. Chairman and committee.
Thank you, sir. Members, that brings us to item number 12 by Leader Lamberth, which is House Bill 430. Sir, you have a motion and a second, properly recognized.
Thank you, Mr. Chairman. This bill deals with facilitation of rape of a child, and for those that were in the subcommittee, I went into the details of this particular horrible, horrible circumstance, but it would raise the penalty on someone who has committed this crime.
Members, you've heard the explanation. Any questions? Seeing none, question's been called. All those in favor of sending House Bill 430 to Finance, please signify by saying aye.
Aye.
Those opposed? Sir, you had to Finance. Next, item number 13, House Bill 478 by Leader Lamberth. You recognized?
Thank you, Mr. Chairman. And this bill, while similar to the one you have, is much more minor in scope.
Leader Lamberth, I'll give you a motion, and you have a second by Chairman Doggett.
Thank you, Mr. Chairman. And again, much more minor in scope, but this will allow for our juvenile judges to have more discretion in certain crimes for those individuals that are juveniles to remain in juvenile court and hopefully not be transferred up to adult court. And so it just gives our juvenile judges a little more discretion in those areas.
Any questions for the sponsor? Question's been called on the bill. Chairman Farmer, you're recognized to call a question. All those in favor of sending House Bill 478 to calendar and rules, please signify by saying aye.
Aye.
Those opposed? Sir, you had to calendar and rules. Brings us to item number 14, House Bill 606, also by Leader Lamberth. Motion.
Second.
Sir, you have a motion and a second, properly recognized.
Thank you, Mr. Chairman. And this bill has been sponsored many times before by many other folks. And again, this comes from a good friend of mine, Norris Skelly, who's a volunteer with Mothers Against Drunk Driving. And this would make vehicular homicide a 100% sentence. There are too many victims families, specifically, that wind up having to go before the parole board and beg the parole board to keep their family member's killer behind bars. It's a murder, whether it's done with, a hammer or a knife or any other dangerous weapon, or if it's done with the car. I mean, when somebody's dead, they're dead forever. And so vehicular homicide should be a 100% sentence. That's exactly what this bill does.
Thank you, Leader Lamberth. Chairman Doggett, you recognized. Question's been called on the bill. Without objection, we're ready to vote. All those in favor of sending House Bill 606 to Finance, please signify by saying aye.
Aye.
Those opposed? Sir, you head to Finance.
Thank you, Mr. Chairman, and thank you, committee members, for supporting those bills. I truly believe they'll help keep our state safer. Thank you.
Thank you, Leader Lamberth. Members, we're going to go back to item number 2 on your list. It's House Bill 511 by Leader Gant. Leader Gant, you are recognized. I also see an amendment coded 4394.
Motion.
Sir, you have a motion and a second on that amendment, and that amendment makes the bill.
That is correct.
Please describe the amendment, sir.
All right, what this does is, after working with Governor Lee for a few weeks on this legislation, we have this amendment that actually rewrites the bill. And this amendment adds a new subdivision under the current definition of terrorism to protect first responders. This amendment ensures that this heinous crime of murdering a first responder in their official capacity will result in 2 options, and that is capital punishment or life without parole. This amendment tightens the language of the original legislation to clarify sentencing. This ensures this offense cannot be pled down because there is no option but capital punishment or life without parole. Once this bill becomes law, it will be one of the toughest, if not the toughest law in the nation when it comes to protecting our first responders. And again, I would like to thank the governor and his team for their input and work on this amendment to ensure that we have the strongest possible language to protect our men and women who devote their lives to serving all Tennesseans. That's the amendment that actually makes the bill, Chairman.
Leader Gant, thank you so much for that description. Thank you for your hard work for first responders and those brave men and women who keep us all safe and rush towards the violence as we often run away from it. I appreciate your work on this. Representative Griffey, you're recognized on the amendment.
Motion on the amendment.
Question's been called on the amendment. All those in favor of attaching amendment coded 4394 to House Bill 511, please signify by saying aye. Aye. Those opposed, you adopt. Members are on the bill as amended. The amendment made the bill. Representative Campbell, you're recognized.
Thank you, Mr. Chairman. Previous question.
Previous question's been called. Seeing without objection, all those in favor of sending House Bill 511 as amended to calendar and rules, please signify by saying aye.
Aye.
Those opposed, sir, you head to calendar and rules.
Thank you, Commissioner. I'm sorry. I have to tell you where that.
I tell you, Leader Gant, I'm just so
from.
happy that we've got representatives from the governor's office in this room because that is an excellent suggestion for promotion, and I really appreciate
the
that.
reason I was not here is I was meeting with the commissioner while y'all were looking for me, so that's where I came from. So sorry.
Good. Leader Lamberth, you're recognized.
Chairman, we're going to let that slide that the leader was literally distracted, not even focused on us in this committee while his bill was voted right on through. I mean,
that's right.
Thank you, Leader.
He's not coming back. What are we going to do? We got Zachary. Oh, we did that. Is that Members, we are unfortunately out of time. We do have one item left on our calendar, but time has expired. Hold on. Members, I apologize. There is one item left. Item number 10, House Bill 374. It is by me. It's actually by Representative Cassada, but I am signed on to it. So he's asked me to run that for him in his absence.
Mr. Chairman, your staff has handed me the gavel. I assume that would indicate you would prefer for me to chair from here on forward?
Yes, sir. Just you were close by, and I know you will do a good job.
Mr. Chairman, I'll do my best. Be glad to serve. All right, members, we're on item number 10, which is House Bill 374, now by Chairman Curcio. Do I have a motion? A motion and a second. Mr. Chairman, it appears that there is an amendment on this, coded 004159.
Yes, sir. That is correct. The amendment makes the bill.
All right, we have a motion and a second. Members, any questions for the chairman on the amendment? Seeing none, will be voted on amendment coded 004159 to go on House Bill 374. All in favor signify by saying aye.
Aye.
All opposed, nay. The ayes have it. All right, members, we're back on House Bill 374. Do we have any questions for the chairman on House Bill 374? Representative Beck.
Thank you to the sponsor. This was voted down in sub and then brought back. And so how does your amendment change the original bill?
I'm sorry, to my friend from Davidson County, there was a different bill that was voted down. This one was successful in the subcommittee and passed through to this committee.
Cancel that order. Thank you.
Thank you, Representative. I believe we have Chairman Halsey.
Thank you. I didn't bring the proper paperwork. What is this bill?
Mr. Chairman, I know you're subbing in for another member on this one, but if you can, just give a brief recitation of the bill.
Be happy to. Thank you, Leader Lamberth, and thank you for the question. Chairman Halsey, this adds a requirement for if a person is serving on a community oversight board where one exists, that they attend the Citizens Police Academy if offered. And the amendment changes, the original intent was you had 6 months to comply. This would change it to 12 months to comply.
Additional questions for the chairman on the bill? Chairman Howell.
Thank you, Mr. Chairman. Question on the bill.
Previous question has been called. Any objections to previous questions? Seeing none, will be voted on House Bill 374. Going to calendar and rules, it appears. All those in favor signify by saying aye.
Aye.
All opposed, nay. The ayes have it. Calendar and rules. Thank you, Mr. Chairman. And, Mr. Chairman, I'll pass the gavel back for adjournment.
Thank you, sir. Members, I want to thank you all very much for your hard work. We had a long calendar to get through tonight. I jumped around because I wasn't certain we would get through it all, but I should have had more faith in this excellent, hard-working committee. So if there's no other business before the committee, we are adjourned. All right. I'll tell Glenn I passed this bill.